Usually when we talk about a legal document, right, or like a modern diagnostic tool, there's this underlying expectation of just sheer mechanical precision.
Oh, absolutely.
I mean, think about the fields of engineering or even modern medicine. You break your arm, the x-ray shows that jagged, undeniable white line running through the bone, and the doctor just points at the screen and says, there it is, that's the fracture.
Right. It's binary. It's clean.
Exactly. You open a modern Western law book, you look up a specific crime, and the penalty's just sitting right there. It's neatly formatted in bullet points, leaving, like, very little room for imagination.
Yeah, we crave that kind of visible, categorized structure, I think. It's comforting, having information that is easily digestible and stripped of any real ambiguity. Modern society operates on this assumption that language should be a one-to-one reflection of reality.
Like a math equation almost.
Right. One word equals one definition, and one crime equals one clearly defined statute on a piece of paper.
But, and this is the crux of it, the moment you step into the world of translating ancient texts, whether they're legal, historical, or theological, that metaphorical X-ray machine just shatters completely.
It really does. It falls apart.
We are suddenly looking at a linguistic and diagnostic landscape that is, well, incredibly murky. You simply cannot run a 1,400-year-old language through a modern internet translation tool,
Or even a standard modern dictionary, honestly.
Right, and expect to understand the intricate architecture of an entire civilization's legal system. The context is entirely different.
When you impose a modern literal dictionary onto specialized historical jurisprudence, you aren't just missing the subtle nuances of the text. You are often completely rewriting the law itself without even realizing it.
Yeah.
Words that meant something highly specific in a 7th century courtroom might mean something entirely generic in a 21st century conversation.
And that profound tension, the friction between modern literal interpretation and deep historical jurisprudential context, is exactly what we are unpacking today for you. So welcome to the Deep Dive.
Glad to be here.
Our mission today, for you listening, is to thoroughly examine a highly detailed, incredibly rigorous scholarly rebuttal. It's titled The Penalty for Adulterer, and this document was authored by Abdul Basit Abdallah.
Right, and to really ground this discussion, I think it helps to understand the catalyst for Abdullah's work.
The spark that started it.
Exactly. This text is a direct academic refutation of a Ramadan lecture given by a Ghanaian politician and lecturer named Mustafa Abdul Hamid.
Right.
Hamid delivered a lecture titled To Repent or to Die, in which he made a very sweeping, definitive claim. He argued that there is absolutely no textual evidence in Islam for the penal stoning of a Muslim adulterer.
Which is huge. Hamid made some exceptionally bold claims in that lecture, challenging centuries of traditional understanding regarding Islamic law, Arabic linguistics, and historical methodology.
He really went after the foundational element.
He did. And in response, Abdullah's text is a step-by-step, methodical deconstruction of Hamid's entire premise. Now, before we venture any further into this material, I need to make a very clear impartiality disclaimer to you, the listener.
Very important.
As your guides on this deep dive, we are operating strictly in neutral territory.
Right. We are not here to take sides in this theological debate. We're not endorsing one viewpoint over another, nor are we here to declare what constitutes absolute universal truth.
Exactly. Our responsibility is simply to impart the arguments precisely as they are presented in our source material. We're going to break down the intricate linguistic mechanics, the historical timelines, and the complex jurisprudential arguments that Abdullah presents in his text.
Just delivering the blueprints, essentially.
We are entirely neutral messengers of this highly complex material. And because of the sheer depth of that material, I need to make a very important announcement right up front. The document we're working with today is incredibly dense.
Oh, it is. It's massive.
It is overflowing with ancient Arabic grammar rules, complex theological paradoxes, and hyper-specific legal history. Trying to cram all of that into a single conversation would just, it would do a massive disservice to the text.
We'd be rushing through crucial details.
Right. Because of that, this deep dive is going to serve as the first edition of this discussion.
There is simply too much ground to cover in a single sitting without losing the profound depth of the arguments Abdallah makes. So you should absolutely expect a second edition in the future where we can explore the remaining layers of this dense material.
Today, we have an incredible intellectual journey ahead of us. We are going to examine the hidden architecture of a single Arabic prefix and how it changes entire legal categories.
We'll look at the intense ancient peer review system used by early scholars to verify historical claims.
We'll explore a heavy theological paradox regarding laws that exist without being written in the main physical text. We will analyze the psychological brilliance of a Friday sermon given by the second caliph, Umar.
And we will see how translating a single word related to marriage can completely alter a legal verdict.
It is a rigorous, demanding text, but it is deeply rewarding if you genuinely want to understand how ancient legal frameworks are actually constructed and interpreted by classical scholars.
It really is.
So, to really grasp the laws of a text, you must first flawlessly understand its language. So that is where we have to begin. The very first claim that Mustafa Abdul Hamid makes in his lecture is foundational to his entire argument.
Right, the linguistics.
He claims that the Arabic language has no distinct word for adultery that is separate from the word for fornication. And therefore, Hamid argues, you cannot logically have a separate, distinct, and much harsher penalty for a crime that doesn't even linguistically exist as a unique entity.
See, Hamid is viewing the Arabic language through a very modern Western lens here. His premise rests on the idea that if a legal system wants to punish two acts differently, it must invent completely separate root words for them.
Because Arabic seemingly uses the word zina for both unmarried fornication and married adultery, he just assumes they must be the exact same crime.
Exactly. And according to Quran 24.02, the punishment for zina is 100 lashes. So he stops his linguistic analysis right there.
But Abdallah counters this by completely opening up the vast, independent nature of classical Arabic. I was actually amazed looking at the vocabulary Abdallah brings forward.
It's incredibly rich.
He points out that Arabic actually has dozens of highly specific words for various concepts, including marital relations. Like he lists words like usala, muqarafa, ifda, firash, and iras.
Yeah.
All of these terms were historically used to refer specifically to intercourse between legally married spouses.
The language was undeniably robust. I mean, Arabic is famous for its hyper-specificity. They have dozens of words for different types of sand or, different ages of a camel.
Right.
So the idea that they simply forgot or failed to invent a word for a specific type of illicit relationship is fundamentally flawed.
Okay, but why then would there be a seeming absence of a highly popularized, distinct, everyday word solely for adultery, as opposed to fornication? Like, if the vocabulary was there, why use zina as this massive umbrella term?
Well, Abdallah provides three profound historical and linguistic reasons for this architectural choice. First, he points out the extremely unpopular nature of the sin among married Arabs, even stretching back into the polytheistic age long before the advent of Islam.
Oh, interesting.
It simply wasn't as culturally prevalent or accepted as other vices. Because it wasn't an everyday occurrence in the cultural zeitgeist, a distinct everyday colloquial word just wasn't culturally prioritized.
That makes historical sense. I mean, language evolves based on utility. If a society doesn't frequently encounter a specific scenario, they don't mint new daily vocabulary for it. What is the second reason?
The second reason is embedded in the mechanical structure of classical Arabic. The language of that era heavily focused on the object of the sentence, the person suffering the action, known as the maf'ul.
The moful.
The linguistic focus was heavily placed on the fact that the coitus involved someone who was not one's legally married spouse. Because the legal status of the object, the person outside the marriage, was the focal point, all acts involving an illicit partner fell naturally under the broader umbrella term of zina.
Ah, I see. Now, the third reason is the one that really caught my attention because it introduces like a psychological strategy into linguistics. It's a concept that is crucial for understanding how this specific legal framework operates.
The third reason Abdallah outlines is that the word zina was deliberately utilized to refer to both fornication and adultery in order to highlight the absolute inherent ugliness of the act.
To make it jarring.
Exactly. The linguistic goal was to maximize deterrence, especially for married individuals who might try to rationalize their behavior. Scholars of Islamic jurisprudence refer to a concept closely related to this linguistic grouping as dilalatu al-itiran.
Dilalatu al-itiran, the strategy of grouping concepts together.
It is the deliberate linguistic maneuver of placing two distinct legal realities under the exact same severe banner. By doing this, the language transfers the immense weight, stigma, and societal revulsion of the broader concept onto the specific act.
Oh, wow.
When you group them, you leave absolutely no psychological room for a married person to rationalize their actions. They cannot tell themselves, well, what I am doing has a different name, so it is somehow different or less severe than base fornication. The language forces them to confront the severity of the overarching category.
Let's contextualize this for the listener, because to a modern ear, using one word for two crimes with two vastly different punishments sounds like a massive vulnerability in a legal code.
It sounds messy to us.
Right. Why wouldn't they just invent a new word to avoid courtroom confusion?
Mhm.
But if I think about modern legal systems, we actually employ this exact same strategy all the time. Think about the overarching term homicide.
Homicide is a brilliant parallel to délatu à la couronne.
If you look at the term homicide in a modern legal framework, it encompasses a massive spectrum of realities. It covers everything from involuntary manslaughter, where someone makes a terrible, tragic mistake behind the wheel of a car, all the way to first-degree, premeditated, cold-blooded murder.
Right. Completely different intents.
But we don't invent entirely separate root words that avoid the concept of homicide. The overarching term homicide exists to highlight the absolute, non-negotiable severity of the baseline act, the taking of a human life. It groups them together for maximum societal weight.
You wouldn't find a defense attorney arguing because there is no separate, unrelated base word for involuntary manslaughter that doesn't fall under the umbrella of homicide. They must all carry the exact same penalty.
Right.
That would be an absurd, catastrophic reading of the law. The modern language groups them to emphasize the severity of taking a life. But the jurisprudence painstakingly separates them for sentencing based on intent, context, and status.
And that is exactly what Abdullah is arguing here regarding zina. The language groups fornication and adultery for maximum moral severity, but the jurisprudence separates them for sentencing based on the marital status of the offender.
Exactly.
Okay, so that establishes that a single word can successfully contain multiple legal realities without breaking the system. But Hamid still anchors his argument to Quran 24.02. This verse explicitly mentions 100 lashes for those who commit zina.
Yes, he leans on that heavily.
Hamid argues that because zina is the only word used, this 100-lash penalty must be the universal maximum punishment for anyone who commits the act, married or unmarried. How does Abdallah use grammar to prove that this specific verse is targeting fornicators and not adulterers?
The entire debate hinges on a tiny two-letter prefix in Arabic, al.
Allah.
In the specific text of the verse, the words used to describe the offenders are azaniatu for the female and azani for the male. The azza sound you hear is simply a phonetic pronunciation rule for the prefix al when it attaches to certain letters. Now, in classical Arabic grammar, the prefix al is incredibly powerful and nuanced. It fundamentally alters the scope of the noun it attaches to. Grammarians divide the usage of al into three broad categories: adiya, jinsiya, and zaida.
This is where we get into the deep linguistic weeds, which is fascinating. A two-letter prefix dictating life or death jurisprudence.
It really does. Hamid interprets the al in this verse as what grammarians call jinsiya. The term jinsiya refers to an entire broad category, a genus or a universal class.
Okay.
So Hamid is reading the verse as applying to the entire universal category of anyone who commits zina, regardless of their marital status. Under his translation, the verse reads, "The entire category of zani, give them 100 lashes."
But Abdallah completely rejects that grammatical reading, and he brings in major linguistic authorities to back him up, doesn't he?
He absolutely does. Abdallah argues that the al in this specific legal verse is not jinsiya, it is adaya.
Idea.
Yes. When the prefix al functions as adiya, it is no longer pointing to a universal broad category. Instead, it is pointing to a specific, previously known and universally understood entity or group within that context. Abdallah asserts that in the specific legal and historical context of this revelation, the al is referring exclusively to fornicators, unmarried individuals.
So it is the difference between saying a car needs tires, meaning the entire genus of cars, versus saying the car needs tires, pointing to a very specific vehicle sitting in your driveway.
That is a highly effective way to visualize it. And Abdallah doesn't just invent this interpretation to win a modern debate. He brings in the heavy artillery of classical Arabic linguistics.
Who does he cite?
He cites Imam Jari el-Aish az-Zamakhshari, a highly renowned linguist and commentator. Az-Zamakhshari's classical commentary on this exact verse explicitly states that the al used here is adiya, specifically in reference to fornicators.
Wow.
Az-Zamakhshari notes that the penalty for adulterous stoning is entirely separate and understood through other foundational texts and practices.
The text also cites a famous poem, right? To prove this isn't just a theological reach by later scholars, but a structural reality of the language itself, dating back to its foundational grammarians.
Right. Abdallah cites Khalil bin Ahmad al-Farahidi, who is essentially one of the absolute titans of Arabic linguistics. He is the architect of much of formal Arabic grammar.
Okay.
In his seminal book, Al-Jumalu Finnawi, al-Farahidi is attempting to explain a very dry, complex grammatical rule where the object of a sentence, the maf'ul, takes up the grammatical features of the subject, the fail.
So he's writing a textbook on grammar, not a book on law.
Precisely. To demonstrate this complex grammatical rule to his students, al-Farahidi casually uses a line of poetry as an example. The poem translates roughly to, "The penalty of what I have committed was, just as stoning was the penalty for zina."
That is incredible. This master linguist is using the reality of stoning for adultery as a baseline, universally understood cultural fact, simply to explain a dry rule about subjects and objects.
Al-Farahidi's own commentary on his poem confirms that stoning is the universally established penalty for the marital form of the act. Abdallah's overarching point here is devastating to Hamid's premise.
Yeah, Lisa.
Abdallah is showing that using basic surface-level linguistics to strike out the penalty of stoning, as Hamid attempts to do, is completely historically uncalled for. The distinct penalty of stoning was a known, unquestioned fact even to the ancient Arabic grammarians who build the very rules of the language Hamid is trying to use.
It truly makes you marvel at how a single prefix, al, can drastically alter the entire trajectory of legal interpretation. It is a stark reminder to anyone listening right now of how crucial original language proficiency is when analyzing historical text.
Absolutely.
You cannot just pick up an English translation, read the word adultery, and assume you have the legal mechanics of a 1400-year-old civilization perfectly mapped out in your head.
A translation is always an interpretation. It is an approximation. It is already a step removed from the intricate mechanical gears of the original text. Relying on it for absolute legal deconstruction is highly precarious.
So, this brings us to a massive pivotal question in the source material. If the underlying linguistics of the Arabic language absolutely allow for a separate punishment for married individuals, but the physical text of the Quran only explicitly lists the 100 lashes for fornicators, where does the severe punishment of stoning actually come from?
That question transitions us into the second major pillar of the debate, the role of the hadith. Hamid acknowledges that if the punishment of stoning isn't explicitly detailed in the physical Quran, it must come from the hadiths.
Right, the recorded sayings and actions.
Yes, the hadith are the vast collections of the recorded sayings, actions, and silent approvals of the Prophet Muhammad. However, Hamid makes a sweeping claim here too. He argues that the specific hadith concerning stoning fail the test of logical consistency and should therefore be entirely thrown out of the legal framework.
Hamid essentially tries to play the role of an auditor. He lays out a list of criteria that he claims a hadith must pass in order to be considered authentic and legally binding. What exactly is the list of requirements he demands?
Hamid claims there are 6 necessary criteria for a hadith to be valid. According to his lecture, an authentic hadith must. Number 1, have other supporting hadith so it isn't isolated. Number 2, have reliable narrators. Number 3, have a continuous chain of narrators. Number 4, be completely consistent with the physical Quran. Number 5, stand the test of modern logic and sound reasoning. And number 6, be supported by established history.
I have to admit, when I first read that list in the source material, it sounded incredibly reasonable to my modern sensibilities. You want logical consistency, you want historical backing, you want multiple sources corroborating a story. It sounds like standard journalistic practice.
It does sound good on paper.
But Abdallah completely dismantles this modern list, doesn't he?
Abdallah absolutely shreds Hamid's methodology. Abdallah points out the fatal flaw in Hamid's approach. Hamid has essentially invented his own modern, pseudo-academic criteria and attempted to apply them backward in time to a highly specialized, ancient science.
Anachronistic.
Completely. In the actual historical science of hadith criticism, a deeply rigorous mathematical field known as al-jarh wa ta'dil, there are 5 strict traditional conditions. And out of Hamid's 6 criteria, he only managed to get 2 of the actual historical conditions right.
Let's look at the real criteria. If early Islamic scholars weren't using Hamid's modern logic test, what were the 5 actual conditions they used to determine if a quote from the Prophet was authentic?
The science of al-jarh wa ta'dil demands 5 simultaneous realities. First is ittisalu sanad, which mandates a continuous, unbroken chain of narrators stretching from the compiler all the way back to the Prophet. Every single person in the chain must have physically met the person they heard it from.
No gaps. No, I heard from a guy who heard from a guy. Documented physical overlap in time and geography.
Exactly. The second condition is Adulterer. This means every single narrator in that unbroken chain must be of impeccable, documented moral character and religious reliability. If a narrator was known to lie in their business dealings, their hadith were rejected.
The character witness phase. Okay, what is the third?
The third is Dabturawi. This is perhaps the most rigorous. It requires the narrators to possess extremely high memory retention and precision. Early scholars would relentlessly test this.
Really?
They
Yeah.
would deliberately read a narrator a list of hadith with subtle mix-ups in the chains or the wording to see if the narrator would catch the errors. If their memory wasn't practically flawless, their narrations were downgraded or discarded.
They were actively trying to trip them up to verify their mental hard drive. That is intense.
Very intense. The fourth condition is Adamu Shuzuz, meaning the hadith in question cannot contradict another hadith that was reported by narrators of a demonstrably higher rank in memory and character, or reported by a much larger group of equally accepted reporters.
So it has to survive cross-examination against the wider, established database.
Correct. And finally, the fifth condition is Adamulila, meaning the hadith must not contain any hidden, highly subtle defects in its chain of transmission or its subtle logic that only master-level scholars would possess the expertise to catch.
When you lay the two lists side by side, you see how much modern baggage Hamid tried to smuggle into the ancient process. Hamid added things like, must not be a lone hadith, must fit modern logic, and must be supported by established history.
Abdallah takes the time to explain precisely why those modern additions are completely invalid within the specific academic discipline. For instance, demanding that a hadith not be a lone report is mathematically arbitrary. The number of narrators doesn't automatically validate or invalidate a historical claim, provided the single narrator passes the grueling tests of memory, character, and unbroken transmission.
Right.
Abdallah points out that the incredibly famous hadith of Umar stating that actions are judged by intentions was essentially a lone narration among the companions for a time, yet it is universally accepted as a foundational pillar of Islamic law because the chain is flawless.
What about Hamid's demand for modern logic? That seems to be the one most people today would cling to. If it doesn't make logical sense to us now, why keep it?
Abdallah dismantles this by pointing out the extreme subjectivity of logic. What is highly logical to a modern politician living in the 21st century might be entirely illogical to a 7th century merchant and vice versa.
That's very true.
Furthermore, within a theological framework, demanding standard human logic is a paradox. Prophetic miracles, the existence of angels, or divine revelation itself, by definition, defy standard, material, human logic. Yet they are fundamentally accepted within the theological framework. You cannot apply material logic to a system built on divine revelation.
I want to inject an analogy here because this clash of methodologies is fascinating. What Hamid is doing is essentially trying to judge a 19th century scientific paper using 21st century internet standards.
Oh, that's a great way to put it.
If you look at a peer-reviewed biology paper from 1850, it followed very specific, rigorous methodologies of its time regarding observation and documentation. You cannot come in today and say, well, this paper is completely invalid because it doesn't include a hyperlink to an open-source data repository, and it doesn't have an SEO-optimized abstract.
Right.
You cannot retroactively apply alien criteria to a specialized historical science. You have to judge it by the rigorous peer review standards of its own era and discipline.
And the science of al-Jarh wa Ta'dil is exactly that. It is the ultimate peer review standard of Islamic textual transmission. And under those actual traditional grueling standards, Abdallah proves that the hadith regarding stoning are not weak or isolated. They are found in the most highly authenticated collections in all of Islamic history, reported by titans of the field like Bukhari, Muslim, Abu Dawood, and Tirmidhi. The historical peer review has already been completed and the text passed.
Speaking of those specific collections of hadith, there is a very telling moment in the text where Abdallah corrects Hamid on a common phrase regarding these books. It really highlights just how precise you have to be with Arabic grammar if you want to enter this debate. Hamid refers to the 6 major books of hadith collectively as the Sihahu Sittah.
Yeah, and Abdallah stops him dead in his tracks right there. He points out that Hamid has committed both a grammatical and a severe categorical error. Grammatically, classical Arabic has 4 distinct elements called at-tawabi, which translates to followers.
Followers, okay.
They are at-taqid, anat, al-adal, and at-taf. Because of how these followers function mechanically in a sentence regarding definite and indefinite nouns, calling them sehalusita is structurally broken grammar. The correct grammatically sound phrasing would be sihausitatu or sihausitatun.
To a layman, that might seem like an incredibly minor, almost petty grammatical correction.
It might seem that way, yeah.
But it leads into a much larger, fatal categorical error that Hamid makes regarding the actual contents of those books.
Exactly. The grammatical flaw exposes a fundamental misunderstanding of the entire science. The term sahih in the specialized vocabulary of hadith studies is not a generic word for good. It is a highly specific category reserved exclusively for a book where the author intended from the very first page to collect only absolutely authentic hadith that met all 5 conditions perfectly.
Okay, so a very high bar.
Out of the famous 6 books Hamid references, only 2 Bukhari and Muslim are categorized as sahih. The other 4 books are categorized as sunan, meaning they collect varying grades of hadith for legal reference. So grouping all 6 of them under the universal title of Sihah is fundamentally incorrect in the specialized vocabulary of the field.
It is a stark warning. If you are going to attempt to dismantle an entire civilization's legal system, you absolutely cannot be making basic errors regarding the titles, categories, and grammatical names of the very books you are attempting to criticize.
Abdallah is systematically making the case that Hamid's entire methodology for discarding the hadith on stoning is built on a crumbling foundation of grammatical errors, invented modern criteria, and categorical misunderstandings.
Having established the validity of the hadith, this pushes us into the deepest and, frankly, the most challenging theological waters of our entire discussion. We have to examine the concept of abrogation, known in Arabic as an-naskh, and the massive controversy surrounding something called Adulterer.
This is truly the philosophical crux of the entire theological debate. Hamid claims that relying on something called Adulterer, which translates to the specific verse of stoning, shatters the entire foundational belief in the Qur'an's sanctity and perfection.
How so?
Hamid builds a very specific argument here. He says that Muslims universally believe the Qur'an is complete, perfect, and preserved eternally on the Lawhul Mahfuz, the preserved tablet in heaven. Therefore, Hamid argues, you cannot claim there was a divine verse about stoning that was somehow lost, forgotten, or left out of the physical pages of the Qur'an we have today.
Because that would imply the Qur'an is incomplete.
Exactly, and its divine sanctity would be ruined.
I have to say, looking at it purely from the outside, it is a very powerful argument on its face. If the book is claimed to be perfect, how can a monumental law involving capital punishment exist that isn't explicitly written in the physical pages we hold today?
Abdallah addresses this paradox head-on by introducing the listener to the highly complex, multi-layered theological framework of an-naskh, or abrogation. Abrogation is the divine process by which a ruling or a specific wording in the text is legally revoked or altered by divine decree during the time of revelation.
Okay, I follow.
Abdallah outlines 3 very distinct types of abrogation to explain how this mechanism functions without breaking the concept of textual perfection.
Let's walk through those 3 distinct types, because understanding them fundamentally changes how you view the nature of this text.
Type 1 is revoking the ruling but keeping the wording. This means the specific law itself is no longer legally active or binding, but the verse remains permanently in the physical Qur'an.
Why keep it if it's not a law anymore?
Abdallah explains the divine wisdom here is to allow believers to continue being spiritually rewarded for reciting the words of the verse, even if the practical law has been updated. An example he provides is Surah 8.66, legally abrogating the ruling found in the preceding verse, 8.65.
So the physical text stays for recitation, but the practical law changes. Understood. Now, let's jump to the extreme opposite end before we hit the controversial middle. What is type 3?
Type 3 is the complete revocation of both the wording and the ruling entirely. The verse is permanently removed from recitation and the law is removed from practical application.
Like it's completely gone.
Right. An example Abdullah provides is a historical temporary rule regarding the specific number of sucklings required to establish a maternal bond that would legally prohibit marriage. Historically, it went from 10 down to 5, and the original text and ruling regarding the 10 were both completely abrogated and removed from the active canon.
That leaves type 2, and this is exactly where the controversy of the stoning penalty lives.
Type 2 is the most complex. It involves revoking the wording, but actively keeping the ruling. This means the specific verse is no longer found in the physical recited pages of the Qur'an, but the legal mandate of the law remains completely active, binding, and enforceable.
Wow.
And Ayaturrav's, the verse of stoning, falls precisely into this unique category.
Here is where the philosophical friction hits its peak. Why? Why would a divine lawgiver deliberately remove the physical text of a law, but fiercely demand that the people still follow the severe penalty of that law? To a modern, legally minded reader, that sounds like a chaotic trap, or at the very least, highly confusing.
It does seem confusing at first glance.
Right, like why not just leave it in the book to avoid 1,400 years of debate?
Well, Abdallah cites a profound theological insight from Dr. Saad bin Nasir bin Abdelaziz Ashathri to explain the underlying why of this mechanism. Dr. Ashathri explains that revoking the wording while keeping the ruling active serves as a profound ultimate test of faith and obedience for the Muslim nation.
A test of faith. Explain how that mechanism works psychologically.
The test is designed to measure the true object of their obedience. Will the believers practice a severe law that they know unequivocally was given to them by the messenger, even if they can no longer find it explicitly written in the physical pages of the book they hold in their hands?
Oh, I see.
It tests whether their obedience is truly to the ultimate divine decree as delivered holistically by the prophet, or if they are just rigidly, mechanically attached to the physical pages like a standard contract. It demands a holistic, integrated obedience to both the Quran and the Sunnah of the Prophet's actions, commands, and approvals.
Wait, I have to push back on this just from a modern structural perspective. Because if something isn't explicitly codified in the main foundational text, isn't it naturally, almost inherently viewed as less binding? In modern Western textual bias, if a right or a law isn't explicitly in the Constitution, it is just a lesser statute.
Sure.
If a term isn't explicitly in the main body of a contract, it is just a verbal agreement that is incredibly hard to enforce in a courtroom. Hamid seems to be heavily operating from this modern constitutional bias. He wants it in writing.
He absolutely is operating from that bias. Hamid points directly to Quran verse 6.38, which translates to, "We have neglected nothing in the book." Hamid weaponizes this verse to say, look, God says everything is in the book, therefore every single binding law must be in the physical Quran.
Which, again, sounds logical to a modern reader.
But Abdallah steps in and breaks down a massive theological misconception here. In Islamic theology, the book mentioned in that specific verse does not strictly refer to the physical recited Quran that people hold in their hands. It refers to Allahu Mahfuz.
The preserved tablet, the cosmic record.
Precisely. The cosmic preserved tablet of all divine decree from the beginning to the end of time. Everything is indeed recorded in that ultimate book. But the physical Quran on earth was never designed to be an exhaustive, bullet-point encyclopedia detailing every single micro-law and societal function.
Okay, that makes sense.
For those operational details, believers are explicitly commanded by the physical Quran itself to follow the Sunnah, the behavior, character, legal rulings, and approvals of the Prophet. Abdallah cites Surah Azab verse 34 and Surah Hash verse 7 to prove that following the unwritten Sunnah is a constitutional mandate of the Quran itself.
There is a brilliant historical anecdote Abdullah includes to illustrate this exact tension about the Sunnah being inextricably linked to the Quran. It is the story about the companion Abdullah bin Masud, and it perfectly encapsulates this exact debate happening centuries ago.
It is a remarkable piece of history. Abdullah bin Masud, a highly prominent companion of the Prophet, publicly stated that Allah cursed certain types of women who altered their physical appearance in specific permanent ways, like tattooing or filing teeth.
Okay.
A woman heard this, approached him, and fiercely challenged his ruling. She essentially said, I have read the physical Quran from cover to cover every single page, and I did not find any mention of this specific curse you are talking about.
She is essentially making the exact same argument Hamid is making today. If it is not written explicitly in the text, it is not a valid law.
Her logic was identical, and Ibn Masud's reply was brilliant. He looked at her and said, if you had read it thoroughly, you would have definitely found it. He didn't invent a new verse. Instead, he quoted Surah Hashr, verse 7, which states, and whatsoever the messenger gives you, take it, and whatsoever he forbids you, abstain.
That is a fascinating legal maneuver. The Quran itself acts as a constitutional pointer to the Sunnah. By commanding absolute obedience to the Prophet within its own pages, the Quran essentially absorbs all of his authentic commands and historical practices into its own legal framework, even if those specific commands aren't spelled out verse by verse in the physical book.
Your modern Western textual bias fails in this arena because you're trying to separate two sources of law that this specific jurisprudential framework demands you keep woven tightly together.
Right.
If you throw out the sunnah because it isn't in the book, you are actually disobeying the explicit text of the book that tells you to follow the sunnah. Abdullah drives this home by listing several fundamental daily practices of the faith.
Like what?
Well, the exact physical movements and times of the 5 daily prayers, the precise words of the call to prayer, the prohibition of men wearing gold and silk, none of these foundational laws are explicitly detailed in the physical Quran. They all derive their legal authority from the Sunnah. If you apply Hamid's logic to stoning, you must logically throw out the daily prayers as well.
It is a domino effect that collapses the whole system. So the theological reality we're left with is this. Abrogation is not a flaw, and is not a missing page or a clerical error by early compilers. It is a deliberate, highly structured theological test of ultimate obedience. And ayat Rajm, the law of stoning, remains legally active and binding through the Sunnah, even though its specific textual wording was abrogated from the physical recitation.
Which perfectly sets the stage for our next point of analysis, because we actually have a highly detailed historical record of this exact legal and theological tension playing out in real time, in a highly volatile political environment. We are going to examine the rhetorical masterclass of Umar's khutbah, his famous Friday sermon.
This historical event is fascinating because Hamid specifically attacks this sermon in his lecture. Hamid claims that Umar, who was the second caliph of the Islamic Empire, gave a Friday sermon that was completely nonsensically disjointed.
Yeah, he really tears into it.
Hamid paints this bizarre picture of Umar standing on the pulpit, talking about the incredibly serious, pressing issue of leadership succession, and then suddenly veering wildly off topic to complain about this missing Ayatul Rajm verse about stoning. Hamid says the speech lacks any logical consistency and proves the stoning narrative is a later fabrication.
But before Abdullah even addresses the deep logic of the speech, he has to act as a historical janitor and clean up Hamid's severely flawed timeline, because Hamid gets the basic documented facts of the event entirely wrong.
Let's do the historical corrections quickly, just to establish the baseline. What did Hamid get wrong?
Hamid claimed the urgent succession discussion happening at the time was about making a man named Ubadah the next caliph. Abdallah corrects this, showing the historical records prove the discussion was actually about a man named Talha.
Okay, wrong person.
Right. Then, Hamid claimed it was Abdurrahman bin Auf who delivered the initial urgent news to Umar while they were at the Hajj pilgrimage. Abdullah points out the historical record shows it was someone else entirely. And most importantly, Hamid claimed Umar wanted to cut his Hajj short in a panic to rush back and give the sermon immediately.
But that isn't what happened.
Not at all. Abdullah shows that Umar actually intentionally delayed the sermon. Abdurrahman bin Auf specifically advised Umar to wait until they had returned to the capital city of Medina.
Why wait?
He warned Umar that delivering such a sensitive, complex legal speech at the Hajj would be dangerous because the Hajj attracted the riffraff, the uneducated masses, and potentially unstable political elements from all over the empire. They wanted to ensure this complex message was delivered strictly to the grounded, highly educated scholars and steady citizens of Medina who could comprehend the nuance.
So the historical foundation of Hamid's critique is already crumbling. But let's look at the actual text and structure of the sermon itself. Hamid says it was a disjointed ramble. Abdallah says it is a masterclass in deep thematic correlation.
Abdullah spends significant time breaking down the brilliant three-part logical consistency of Umar's speech. When you understand the underlying legal mechanics we just discussed, you realize Umar isn't rambling at all. He is building a profound, multi-layered, airtight legal argument.
Let's walk through the architecture of this speech, layer by layer. How does Umar open?
Umar opens his sermon by addressing Ayatul Rajm. He talks about a severe law, the stoning of adulterers, that everyone knows is not explicitly written in the physical Quran, but is heavily, undeniably mandated by the Sunnah and the historical practice of the Prophet.
Okay.
He uses this opening to establish a firm, undeniable precedent right out of the gate. Unwritten, Sunnah-backed laws are absolutely valid, divine, and legally binding on the population.
It is a psychological primer. He is reminding the people, we all agree that we follow foundational laws given by the Prophet, even if we can't point to them on the physical page. Once he gets them nodding along to that reality, where does he pivot?
Having firmly established the ultimate authority of unwritten sunnah, Umar transitions seamlessly into the highly volatile topic of leadership and succession.
Which, crucially, is also an unwritten rule. The physical text of the Quran does not explicitly spell out the exact mechanical process for how to elect or transition to a new caliph.
That is the genius of the transition. The entire mechanism for leadership succession, electoral councils, and swearing allegiance is guided almost entirely by the unwritten sunnah.
Oh, wow.
Umar then deploys a deeply powerful metaphor. He talks about how subjects cannot arbitrarily deny or rebel against their legitimate caliph, just as a biological son cannot logically or legally deny his biological father. He establishes the absolute binding necessity of obedience to the legitimate, sunnah-ordained leader.
And how does he close the argument?
Umar concludes the sermon by mentioning a specific historical moment where the prophet strictly forbade people from excessively praising him beyond his station as a mortal messenger of God. Umar takes this historical precedent and directly links it to the memory of the first caliph, Abu Bakr.
So it's warning.
Exactly. He is issuing a stark warning to the people. Do not overpraise, deify, or blindly worship your political leaders, past or present.
If we step back and view this as a single cohesive unit, the rhetorical genius is staggering. Umar is dealing with whispers of a succession crisis. People in the empire are questioning the legitimacy of leadership transitions because the specific rules aren't explicitly written in the Quran. So what does Umar do? He doesn't just yell at them to obey his authority. He builds a foundational legal framework in their minds.
He essentially traps them in their own jurisprudence. He uses ayatul rajm, a severe, universally known and practiced penalty that relies entirely on unwritten sunnah to prove that unwritten sunnah is undeniably legally binding.
Brilliant.
Once the scholars of Medina agree, yes, stoning is the law even though it's not in the book, he pivots. He essentially tells them, therefore, by your own accepted legal logic, the unwritten sunnah of how we elect and obey a caliph is equally valid and binding. He establishes the validity of unwritten sunnah regarding a criminal penalty to completely legitimize the unwritten sunnah of leadership succession.
It is fiercely cohesive. It is the absolute opposite of a disjointed ramble. It is a brilliant psychological and legal maneuver to stabilize the entire political structure of early Islamic governance by tethering it directly to a shared, undeniable understanding of jurisprudence.
Abdallah proves conclusively that Hamid's inability to see the connection isn't a flaw in Umar's speech. It is a fundamental flaw in Hamid's understanding of how these ancient legal concepts and unwritten authorities intertwine.
Which brings us to the final, highly specific area of our legal analysis today. To conclude this massive deconstruction, Abdallah focuses intensely on the exact hyper-specific terminology used to condemn someone under these laws, pushing back hard against the simplistic modern dictionary translations that Hamid relies on to make his case.
Right, the words themselves. Hamid looks closely at the specific Arabic words Umar used in that famous sermon to describe the adulterers. The words Umar used are sheikhu for the male offender and shayha for the female offender.
Sheikhu and sheikh.
Hamid opens a standard modern dictionary and argues that sheikhu literally translates to an old man, a clan leader, an elder, or a head of a tribe. Therefore, Hamid says, using this specific word to mean adulterer is completely nonsensical and illogical.
He takes it completely literally.
Exactly. He asks his audience, is every single clan leader married? Does every adulterer have to be a tribal elder? Hamid uses this literal, surface-level dictionary translation to claim the entire hadith and the sermon fall apart logically.
It goes right back to our opening metaphor about the X-ray machine. Hamid is looking at a complex, specialized medical chart and reading the literal Latin root words instead of understanding the applied contextual medical terminology. How does Abdallah correct this translation error?
Abdallah pulls out the heavy classical dictionaries, specifically relying on Muhammad bin Yaqub's globally renowned classical lexicon. Abdallah points out that classical Arabic is hyper-contextual.
Very contextual.
While it is true that sheikhu can mean a clan leader or an elder in a broad political or social context, in a specific relational and legal context, specifically when it is phrased as a tunai, or sheikhu of the woman, the term sheds its political meaning and translates precisely and exclusively to her husband.
That completely changes the landscape of the sentence. It has absolutely nothing to do with being a tribal leader or an old man in this legal context. It literally just identifies the man's specific legal relational status to a woman. He is legally bound as a husband.
And the female equivalent, sheikha, in this context, identifies her specifically as a wife. The terminology Umar is using is hyper-specific to their marital status, which, as we established earlier, is the entire necessary prerequisite for the specific punishment of adultery. He isn't talking about old people, he's talking about married people.
And there is one more critical legal term that Hamid trips over in his lecture regarding the status of the offender, the word musan.
Yes. In the broader books of Islamic jurisprudence, the specific technical term used to describe a married person who is eligible for this specific punishment is musan for a male and musana for a female.
And how does Hamid translate it?
Hamid again relies on a generic translation. He argues that musan simply means a chaste person or a clean, pure person. And since a completely unmarried single person can obviously be chaste and pure, Hamid argues that using musan to strictly mean a married adulterer breaks the foundational logic of the grammar.
How does the historical jurisprudence actually define musan when it's used in a courtroom setting?
Abdallah introduces the incredibly detailed jurisprudential breakdown provided by none other than Imam Ash-Shafi, who is one of the four great foundational imams of Islamic law. Ash-Shafi explains that you cannot just look at the modern translation, you have to look at the mechanical root word, which is at-tassin.
At-tassin, let's break that down.
At-tassin literally means protection, fortification, or being shielded from engaging in prohibited acts. It implies a fortress. Ash-Shafi details how various structural things in life act as an at-tassin for a human being.
Give me an example.
Well, the religion of Islam itself acts as a protection. Freedom from the bonds of slavery is a legal protection. Being placed under physical house arrest is a literal physical protection from committing outside crimes. And crucially, within Islamic sociology, marriage acts as an at-tassin.
So it's a fortress.
Exactly. It protects and fortifies a person's chastity by providing a completely lawful, sanctioned avenue for natural human desires.
The legal architecture suddenly makes perfect sense.
Therefore, in this highly specific legal context of sexual crimes and penalties, a musan is not just a generically chaste or clean person. A musan is specifically defined as someone who has been granted the at-tassin, the fortress and protection of a lawful marriage. They are a deeply protected person who willfully stepped outside of that fortress and violated that protection.
It is truly incredible how a literal, generic dictionary translation can completely derail your entire legal understanding if the historical and jurisprudential context is ignored. If you just look up musan, you might see chaste, and your entire legal thesis goes down the completely wrong path, leading you to declare a 1,400-year-old system illogical.
And that's exactly what happened with Hamid.
But if you look at the root mechanics of the law, it means one who is fortified and protected by the institution of marriage.
It perfectly proves Abdallah's overarching thesis throughout this entire text. You absolutely cannot deconstruct classical Islamic jurisprudence using modern superficial linguistic tools. The complex architecture of the Arabic language and the deep mechanics of the law are fused together at a foundational, inseparable level.
Let's step back and summarize the massive intellectual journey we have just taken today. We started by examining the prefix al and the psychological strategy of Dulatu Ali-Duran, grouping crimes to maximize deterrence. We moved through the incredibly rigorous, highly structured ancient science of hadith criticism, discarding modern arbitrary criteria in favor of the intense peer review system of al-jarh wa ta'dil. We waded into the deep, challenging theological waters of an-naskh, understanding how the abrogation of Ayatul Radham's wording serves as a profound, ultimate test of faith and obedience for the Muslim nation.
It's a lot of ground covered.
It is. We watched Caliph Umar brilliantly weave the unwritten law of stoning into a psychological and rhetorical defense of leadership succession. And finally, we saw how the hyper-specific legal definitions of marriage and protection, shaiku and musan, completely dismantle simplistic modern dictionary translations.
The overarching lesson here highlights the vital, non-negotiable importance of engaging with specialized scholarly traditions strictly on its own terms, rather than arrogantly imposing our own modern frameworks and biases onto it.
Which leaves me with a final provocative thought for you to ponder as we close. We started this deep dive talking about how modern law is like an X-ray clean, binary, easy to read. But as we've seen, ancient jurisprudence is an entirely different, highly complex living organism. It makes you wonder, how much of modern historical and legal debate, not just in Islamic law, but in all ancient texts, from the framing of the Constitution to the translation of ancient philosophy, is purely the result of us losing the nuance of specialized vocabulary?
When we impose our modern dictionaries, our modern legal biases, and our modern assumptions onto ancient classical texts, are we actually reading their intricate laws? Or are we just using their ancient words as a mirror to project our own modern reflections back at ourselves?
It is a heavy, necessary thought to sit with. And remember, this was only the first edition of this deep dive. The source material from Abdul-Basit Abdallah is an absolute treasure trove of intellectual rigor, and there is still so much more vital information to unpack in his refutation. Stay curious, keep critically questioning the simple translations you read, and we look forward to guiding you further in the second edition.